All right, so this is our first snippet for this week, which looks at constitutional history during the Bush years, with an emphasis on national security questions and in the aftermath of 9/11, and judicial appointments. It's a very famous photograph of Bush in New York City the day after the attacks. One of the effects of the attacks was to dramatically expand the power, at least for a couple of years within the administration, of the Vice President, Dick Cheney, who was something of a hardliner, shall we say, on terrorism issues. And Cheney's philosophy had a couple of sort of unusual points with regards to how the war on terror intersected with the Constitution. The first was he people around him floated this idea of a 1% doctrine, that given the severity of the threat, it was important to act even if there was only a 1% chance of the United States being attacked. And I mean, you do get a sense that there was some maybe suppressed guilt, that they hadn't done more to prevent 9/11. But in any case, this is very, very aggressive approach, to sort of handling terrorism threats. And the second, which was very popular in the Bush White House, was this idea of a unitary executive theory, that yes, the president, yes, the U.S. has signed treaties, and yes, the president is one of three branches along with the legislative and the judicial. But in defending the sovereignty of the United States against threats to the existence of the republic, just as Lincoln did with ex parte merriment, it was the administration really had no limits on its power. And the Bush administration's Office of Legal Counsel, it's called OLC. It's basically the kind of official lawyer of the president. Issued a series of memoranda in the aftermath of 9/11, once the United States moved into Afghanistan and began to capture suspected al-Qaeda terrorists. And this is almost all of the critical of these memoranda were all later repudiated by the Bush administration or by the Obama administration. And here, this memo, which was co-authored by two Bush appointees, a man named Jay Bybee, who is now a federal appellate court judge, and John Yoo, who's now a law professor. You can get a sense of it from the areas that I've bolded here in red. So the first is this idea that the structure of the Constitution demonstrates that the conduct of war, unless it's expressly assigned to Congress, is vested in the president. This is in some ways a counterintuitive view of the Constitution. And then the second, that the president had the authority to override anti-torture law or treaties if he felt it necessary to prevent an attack on the U.S. soil. The euphemism used were enhanced interrogation techniques, but the conduct here, which was done by CIA interrogators, fit the international definition of torture. And the result of this was the capturing of al-Qaeda troops, of al-Qaeda or suspected al-Qaeda operatives. Some of them, of course, were al-Qaeda operatives. Their imprisonment at the U.S. Naval facility in Guantanamo Bay, and then the Bush administration's argument in a series of court cases that this vision of executive authority meant that the detainees in effect had no constitutional rights at all. And this viewpoint got challenged in a couple of Supreme Court cases. Here's an excerpt from one of them. This is Justice Kennedy pressing the Solicitor General, arguing on behalf of the Bush administration, and Justice Breyer as well, trying to examine whether there were any limits on the argument, this executive authority argument that the Bush people were making.
I'm interested in your arguments on the legitimacy and the regularity of these commissions.
And if I could talk to various aspects of that, I'm happy to do so.
Can I put that issue in? Don't ignore my question, which is the same as Justice Kennedy's, if it doesn't help. I'm trying to focus this. And in my mind, I take their argument as saying, look, you want to try a war crime. You want to say this is a war crimes tribunal. One, this is not a war, at least not an ordinary war. Two, it's not a war crime. because that doesn't fall under international law. And 3, it's not a war crime tribunal or commission because no emergency, not on the battlefield, civil courts are open, there is no military commander asking for it. It's not in any of those in other respects like past history. And if the president can do this, well, then he can set up commissions to go to Toledo, and in Toledo pick up an alien and not have any trial at all except before that special.
So the special commissions to which Kennedy and Breyer were referring were military tribunals that had been set up in response to the to an earlier case by the Bush people before the Supreme Court. The Supreme Court said, you have to give some sort of trial. And this decision, that previous case was called Hamdi. This case is called Hamdan versus Rumsfeld. Rumsfeld was the defense secretary in the Bush administration. The Supreme Court, by a vote of 5-3, with Justice Roberts recused, says that there has to be some constitutional rights for terrorism suspects, and the critical line I have bolded in red: in undertaking to try Hamdan and subject him to criminal punishment, the executive is bound to comply with the rule of law that prevails in this jurisdiction. That is, that the president can't simply say, I get to interpret the Constitution, and if I say these people don't get to have a trial because a trial would be dangerous to national security, they don't get a trial. The Supreme Court says no. Now, this litigation is incredibly still ongoing. There are still detainees held in Guantanamo, but both Hamdi and especially Hamdan are at least affirmations by the Supreme Court that there's some limitation in terms of presidential power, national security in the war on terror. Now, if you look down here at the bottom, you see Alito and Roberts. These are the two new Supreme Court nominees. The first Bush nomination comes when Justice O'Connor, whose husband was terminally ill, announces that she's going to retire, and the president announces that he's going to replace her with John Roberts. And then shortly after that, Chief Justice Rehnquist passes away, and Bush then announces that he's going to move Roberts, a Republican lawyer who had served in the Reagan administration, was seen as very conservative, very, very smart, was going to move Roberts and nominate him as Chief Justice instead. And Roberts, in his nomination hearing, uses a baseball analogy, which proves to be very persuasive with public opinion. The argument that he makes is, look, the job of a judge or a justice, in his case, is simply to call balls and strikes. That he sees an opinion as it comes before him. If it fits into the strike zone, that means the petitioners win. If it's outside the strike zone and it's a ball, that means the respondents win. It's a homey analogy, and basically what he's arguing here is that a judge should not substitute his or her view of the merits of the case for what the law might be. Now Roberts' critics argue, look, when a case makes it to the Supreme Court, it's the equivalent of, say, a pitch on the corner. That the strike zone here analogy doesn't really help us because some umpires could call this pitch a ball and some umpires could call this pitch a strike. And so getting a sense of how the umpire, or in this case the justice, thinks about these issues is important. But Roberts declines to answer any meaningful questions. He retreats to this analogy and prevails. So Roberts is confirmed. The question then is, who is going to replace O'Connor? And there is some sense that Bush would want to replace O'Connor, who, after all, was the first female justice on the court and the only woman nominated by a Republican president up until this point. Of course, Justice Barrett has now been was nominated by Trump, but the only woman nominated by this point with another woman. And the front runners for this seem to be Edith Jones, who is a judge in the Fifth Circuit, which is Texas, Louisiana, and Mississippi. Priscilla Owen, who is also a judge in the Fifth Circuit. Both of them very conservative, very, very smart judges. And Janice Rogers Brown, which would have been the first Black woman ever nominated to the Supreme Court, a judge in the D.C. Court of Appeals. The problem with all three of these judges, and especially Brown, is that they are perceived as too conservative to make it through a Republican Senate. Brown is very, very conservative. And ultimately, Bush falls back. He still wants to nominate a woman. So he nominates a friend who works in the White House counsel's office named Harriet Meyers. The problem is that Myers's knowledge of constitutional law seems not terribly great, and she performs very poorly in interviews with individual senators, and so she's withdrawn before she even has hearings. There's a fear among conservatives that she's a kind of closet liberal, and there's this famous story where she's asked by one senator, who is your favorite Supreme Court justice? And of course, if you're a conservative, the answer here would presumably be Scalia or Thomas. Instead, she says Warren. Now, Earl Warren is probably not the high point among among conservatives. And then when there's a lot of outcry over this, and the Bush administration releases a statement saying that when she said that, she didn't really mean Earl Warren. She meant Warren Burger, the Republican Chief Justice between 1969 and 1986. Of course, she didn't. One suspects that what happened is that she froze, and Earl Warren was the only justice that she could immediately think of. But Meyers is sunk. The 2006 elections are coming up. There's a fear, turns out correctly, that the Republicans are going to lose the Senate, and so ultimately Bush turns to Samuel Alito, a kind of middling appeals court judge from the Third Circuit, based in Philadelphia. Alito's confirmation is hard fought, but he is confirmed 58-42. All of the 42 no votes are Democrats. There is a filibuster against Alito, but some of the Democrats who vote no nonetheless allow the vote to go to the floor. This is the last time this is going to happen, where you get this kind of split between support in general and allowing the nomination to proceed. Roberts and Alito are sort of seen as comparable judges. They're both appointed by Bush, after all, at roughly the same time. But Alito is noticeably more conservative than Roberts is, somewhat less of an institutionalist. Roberts doesn't want to appear biased. Alito doesn't really pull any punches. The net result of this is to move the court to the right. Roberts is replacing Rehnquist. There's really no change there, but Alito is replacing Justice O'Connor, and so he's on the right fringe of the court. And the result is that over the next several years, starting in the term of 2006, when Alito and Roberts joined the court, the dominant justice here is Kennedy. And in 5-4 cases, I'll walk you through these tables. The red pie in these tables are 5-4 votes in which Kennedy votes with the 4 conservatives. The blue pies are votes where 5-4 votes where Kennedy votes with the 4 liberals, and the yellow pies are something other than that. So basically, if it's a contentious ideological case, and it's a 4-4 split, Kennedy is going to decide what way the vote goes. And over this period, Kennedy is in the majority far more so than any other justice. And this will continue right up until he retires from the court in 2018. There are few justices, especially if they didn't serve as Chief Justice, who are more powerful for a longer period of time than Kennedy is. All right, and that's our first snippet.